Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, but as uncertified podcast co-hosts, we try to bring our audience of trial and appellate attorneys some news and insights they can use in their practice. As always, if you find this podcast helpful, we would love it and appreciate it if you'd recommend it to a colleague.
And if you don't like it, it's a wonderful natural sleep remedy. Before we jump into this week's discussion, we want to thank again Casetext for sponsoring our podcast. Casetext is a legal technology company that has developed AI-backed tools to help lawyers practice more efficiently since 2013. And Casetext is relied on by 10,000 firms nationwide, from solo practitioners to AmLaw 200 firms and in-house legal departments. In March 2023, Casetext launched CoCounsel, the world's first AI legal assistant. CoCounsel produces results lawyers can rely on for professional use while maintaining security and privacy. Listeners of our podcast enjoy a special discount on Casetext basic research at casetext.com/CALP. That's casetext.com/CALP.
Yeah, and Jeff, I'll tell you a recent success story that I've used Casetext for in the AI product CoCounsel. I've been using it I just keep it up while I'm writing a brief, and I just kind of if I have a cockamamie idea and I want to see if it's cockamamie or there's something to it, I just plug it in, have it do a quick junior level associate. Junior associate level quality brief, and sometimes it'll spit out some cases that I hadn't found before, and that become very useful. So I'll get to the end of my brief and just think, okay, well, let me just check these cases that CoCounsel found for me, and I find the case cracker in there, and I just did that recently.
It's like having a tireless first-year associate who never sleeps.
Yeah, never complains, never talks back. All right, Jeff.
And you get the same quality.
That's right. We are continuing our tour through some recent April, and now we're into May 2023 cases. And our last episode, we covered several concerning appealability and timeliness issues. Today, we have some cases involving anti-SLAPPs, sanctions, settled statements, record defects, and more. So let's get right to it. The first case we're going to cover is Salveson versus Kessler. It's about anti-SLAPP denials. They are appealable in the Ninth Circuit, but, says Judge Bress, they shouldn't be. So this case came out of the film production involving where Alec Baldwin had accidentally killed somebody using a prop gun that was, unbeknownst to him, loaded. The cinematographer died in that case. But this is a spin-off case, a civil lawsuit, Salveson versus Kessler, out of the Ninth Circuit. And the Ninth Circuit holds that the civil case, which involves the producer's claims concerning his former lawyer's business and tax practices, holds out no issues of public interest for purposes of the anti-SLAPP statute. So uninteresting were the claims, in fact, and so devoid of protected conduct that Judge Bress separately concurred, asking why is this appeal even kicking around, sucking up a year of everyone's time while the case languishes under a pointless appellate stay back at the district court. Judge Bress pointed out that the anti-SLAPP law and the immediate right to appeal from denials of anti-SLAPP motions are procedures specific to California law, but the Ninth Circuit has its own procedures, and under those procedures, there is no immediate right to appeal from anti-SLAPP denials. And in fact, Jeff, as we know, there is no federal anti-SLAPP law or procedure at all.
Yet.
Not yet. There should be, if circuits are embracing them, rather than try to graft them onto existing ill-fitting procedural statutes. It'd be nice if Congress would just pass its own anti-SLAPP statute. Judge Bress writes, quote, "This piecemeal appeal, which our precedents unjustifiably allow, has resulted in a totally meritless anti-SLAPP motion delaying this litigation by nearly a year. This is neither sound as a matter of law nor sensible as a matter of litigation management." End quote.
Yeah. So, Judge Bress is really complaining about a SMAC, a strategic motion against credible claims, right? The kind of anti-SLAPP motion that's clearly frivolous, has no prayer of being granted, and yet it's filed, and then when it's denied, it's appealed, and the litigation grinds to a halt. And I have this to say in response. First of all, a true SLAPP, a lawsuit that is clearly and demonstrably frivolous, there should be the right of immediate appeal always to weed out frivolous lawsuits like that. What this judge is complaining about is smacks anti-SLAPP laws used for a credible lawsuit where the anti-SLAPP motion should never have been filed. Here's my easy solution. Let's amend 425.16 to make it a little easier for the winner of an anti-SLAPP, the winning plaintiff, to get sanctions, a little easier to show that it's a frivolous anti-SLAPP motion, and amend the statute to say when the judge at the trial level declares it to be a frivolous anti-SLAPP, a smack, if you will, deprive that litigant of the right of immediate appeal. You go up on a writ if you want to seek immediate review while the case proceeds to discovery. Yeah. That is the Jeff Lewis solution.
Yeah, I'd co-sign the Jeff Lewis solution to the anti-SLAPP law. Jeff, so you have there's two prongs of that solution, matching the two prongs of the anti-SLAPP procedure. The second prong, denying the right to appeal a denial of an anti-SLAPP, that would require a legislative amendment. But the first part of your proposal, which is to make sanctions motions filed by the successful opposing plaintiff easier to win on, would that require a legislative amendment?
Yeah, maybe I misstated it. If judges started sanctioning defendants who file smacks more as a matter of practice, you wouldn't need a legislative amendment. And in terms of the appeals, over the years, since the statute was enacted, the legislature has carved out a number of areas where there is no right of immediate appeal. I think if the commercial exemption applies, there's no right of immediate appeal. And I think in a slap back action, there's no right of immediate appeal. You got to go by way of writ. So this would be an easy legislative amendment.
Yeah, and I agree. If the judges at this point, I think, could look and say, look, we now have a well-developed, mature body of case law interpreting the anti-SLAPP statute. So defendants, by now what is a meritorious anti-SLAPP motion and when you are being too clever by half. And so we're going to grade these successful plaintiffs' motions for sanctions for filing a frivolous motion accordingly. And give a little bit more, the decks are going to be stacked a little more favorably toward the plaintiff on granting those motions.
Yeah, absolutely.
All right, but back in the Ninth Circuit, allowing the Ninth Circuit rule that allows immediate appeals and appellate stays after denials of anti-SLAPP motions may be modified only by U.S. Supreme Court decision or by the Ninth Circuit sitting en banc. So a 3-judge panel, as much as they might like to, are powerless to change the rules.
Yeah. Or an amendment to the state law, the state anti-SLAPP law. I'm sure the Ninth Circuit wouldn't mind anything that reduced the number of appeals of smacks.
Let's hope so.
Yeah.
All right. Next case is Kendrick versus Wyckoff. An oral record on appeal was required to review the validity of a trustee notice to beneficiaries. The reason I flagged this, Jeff, is because we've talked oftentimes about the court reporter shortage crisis and how that wreaks havoc on litigation practice. If you can't find a court reporter, or if you can't afford a court reporter, if you have access to justice issues, you have to scrutinize whether you really need to hire a court reporter. They're not cheap. They don't work for free. If you're not certain you're going to need it on an appeal, you might decide, look, I better not have it. But there are a lot of cases that still will imagine that there are things going on at the hearings that require a verbatim record, or some form of oral record. So that's what happened in Kendrick versus Wyckoff out of the First District. So probate departments recently have stopped providing court reporters, and California needs, some 2,700 court reporters to fill the gap. And so, the question is, do we really need to have court reporters in all the proceedings? And in Wyckoff, a trust beneficiary challenged the validity of a trust amendment. He claimed that the trustee's notice to the beneficiaries under Probate Code 16061.7 was invalid. And that sort of thing is normally determined just by looking at the documents. Is it a valid notice or an invalid notice? Do you need testimony on that sort of thing? Probably not. You just look at the documents. But the Court of Appeal here said that it would not review the issue on appeal unless it had an oral record of the hearing. And no oral record, said the Court of Appeal, meant that the order had to be affirmed. Quote, without a record of any evidence received at the hearing, we must presume the evidence supports the trial court's findings and its resulting orders were appropriate based on these findings, end quote. So, Jeff, my comment on this is that, the requirement that an oral record be supplied already imposes difficult technical and administrative burdens on less well-heeled litigants, but especially so given the court reporter shortage. And if the respondent indicates, in its brief that hey, yeah, there really was something that happened at the hearing, and the appellant failed to provide it. Here's a gist of what it is. This is the sort of thing that the trial court considered, and it did. It is entitled to substantial evidence review, and therefore the appellant didn't make that burden and has to be affirmed. That's an argument I can get behind. But just imagining that maybe there was something that happened when the issue on its face doesn't seem like it requires any testimony or subtleties that would have happened at the hearing. It seems a little too cavalier to fault the appellant for that.
Yeah, look, a classic example is attorney's fees. When you're arguing over the amount of attorney's fees on an appeal, first of all, you shouldn't be appealing that, because that's a big hill to climb, trying to disturb the trial court's discretion on the amount of attorney's fees. But let's say you're appealing that. If you don't have a record of the oral proceedings, the Court of Appeal can say you forfeited the issue because there's no record and there's no settled statement. I don't know what the Court of Appeal does with the reporter's transcript on an attorney's fee motion. Do they really need to see what the trial court's comments were in a non-evidentiary hearing regarding the papers that are already before the Court of Appeal? I don't get it. I don't understand the value in that context.
No, I don't get that either. Again, it may depend on the issues and arguments being raised. If the appellant is arguing that, oh, look, the judge didn't consider my argument about the overbilling or the block billing, and well, maybe there was some discussion on the record about that indicates that the judge did consider those issues. But otherwise, yeah, you're right. I mean, unless there are witnesses sworn in, I'm not sure what the point is in having a verbatim record or an oral record of the proceedings. Yeah, I'm not sure what is turning the tide in these other cases. All right, the next case, also on the subject of oral records of proceedings, is Rock Mobile Inc. versus Brannon out of the 2nd District. Use a settled statement to fill gaps in your record, but don't try to rewrite the record. So here is an example of an appellant who knows that they needed an oral record of the proceedings, didn't have a verbatim court reporter's transcript, so decided to use a settled statement. But here's a good example of what a settled statement is not to be used for. So on appeal from the denial of his motion to set aside the judgment, in this case, Rock Mobile, the defendant Brannon came up with this clever application of the settled statement process. So remember that a settled statement is a summary description. It has to be a fair and balanced summary description of the documents or oral proceedings in the trial court. Brannon put together a proposed settled statement and said that he never got notice of the October default. And this, Brannon hoped, would be good grounds to get the default judgment vacated. But the settled statement contradicted the declaration of Rock's counsel in the written record. Rock's counsel declared under penalty of perjury that he mailed Brannon the default the day the court clerk entered it. So the court concluded, we reject this use of the settled statement. Besides, the court went on, non-receipt of the notice of default shall not invalidate or constitute ground for setting aside any judgment, citing Code of Civil Procedure 587 and case law. So the comment on this, Jeff, is that you should still consider the appellant's example and use a settled statement to fill any gaps in your appellate record. Just don't try to use a settled statement to rewrite the record, to contradict facts that are in there, or to supply facts that were never actually offered into the record. But if there are documents or if there's an oral transcript that are not available to show what happened, you should consider using a settled statement. It's not that difficult of a procedure. It's just so many of the ones that do come up are fumbled or attempted abuses of the procedure.
Yeah, or in this case, the trial court wrote according to this Court of Appeal opinion. The trial court wrote in response to the proposed settled statement, "I've got no idea what happened. I don't remember. There was no court reporter there." And so the settled statement was of little use in this particular case. And I don't know how trial judges go through the process of trying to recreate something that happened 6 or 9 months ago. It's crazy.
Well, that's right. And that's why part of the procedure, if you're going to do it, you need to do it almost contemporaneous, like day by day.
Yeah.
And don't try to do too much. It doesn't replace a verbatim record. So don't try to get the court to sign off on specific verbatim statements that were made, because then the court will say, I can neither confirm nor deny that this is precisely what was said. So you just have to do a fair narrative. If your case is going to turn on a particular way a witness said something, then forget about it. If you don't have a verbatim record, then you're not going to be able to replicate that with a settled statement. But some good possible applications of a settled statement could include, showing what happened during a sidebar. That happens even when you do have a court reporter there. If a sidebar is out of the hearing of the court reporter, you can use a settled statement to describe a demonstrative exhibit. That happens a lot. I see that a lot in the record when I'm reading an oral transcript of the trial, and I keep seeing references to a demonstrative exhibit. I don't have a copy of it. It's not described anywhere in the oral record. It would be nice to have a settled statement that some record of what that demonstrative exhibit was. You can use a settled statement for that. You can describe what happened at a law in motion hearing, as you were talking about, Jeff, like the quintessential example of a attorney fee motion. If you think that the respondent is going to try to club you over the head on appeal because you don't have a verbatim record, then maybe just a quick settled statement containing a brief narrative of what happened. You can capture your request for an evidentiary hearing or a request for a statement of decision. If that was made at an oral hearing, capture that in a settled statement. And you could capture your objections to jury instructions. Those often happen in camera, and seldom do trial attorneys drag along a court reporter into the judge's chambers.
Yeah.
Okay. Next case. This deals with one of those situations during that period right in between, kind of in that twilight period after trial, but before the appeal. This is where a jury was released from duty. The court held that that jury could not be reconvened later on when it was learned that the jury needed to make an additional finding. This is People versus Jones out of the 1st District in April 2023. The lesson here is do not forget to have the jury make all of the required findings, because once the jury is discharged, as happened in People versus Jones, the court loses control of the jury. And so the jury cannot be reconvened. So that's the standard of this case is the court has to have control of the jury at all times. Once it loses control, cannot be reconvened. So what happened in Jones is that the prosecutor had charged an enhancement. This is a criminal case, but I think the same standard would probably apply in civil proceedings, Jeff. The prosecutor had charged an enhancement based on a prior serious felony. The jury returned a guilty verdict, but did not make a finding that the defendant had committed the prior serious felony before the trial judge had thanked the jury for their service and released them from their duties. By the time the jurors were brought back in, some 4 hours had passed, and no one, at least the record, could not account for exactly where they were or if they had left the building. A jury that has been released may be reconvened, but only if the jury has remained in the court's control. The court did note that the jurors had not left the courthouse. I misspoke. The record, at least according to the record made by the judge, reflected that they were still somewhere abouts in the courthouse, but the record was silent whether the jurors had abided by the previous admonitions, especially given the fact that the judge had released them from their duties. And the court said that, quote, given such a paucity of evidence, we cannot conclude that the jury remained within the court's control.
Right. And key there was the judge's instructions on discharge saying, hey, every day I've told you you're not allowed to talk about this case, but today I'm discharging you and you're now free to talk about the case. I'll tell you one thing that struck me when I read this case was it wasn't clear to me when defense counsel pointed out to the judge that, hey, there's one more charge we got to deal with, that the defense counsel objected. when the jury was brought back in. It wasn't clear to me, and I wonder if there's an issue of waiver or invited error. It wasn't briefed, wasn't discussed in the opinion, but I'm just curious if the defense attorney had objected.
Yeah, that's a good point. I don't think it was clear in this case whether this was a structural error, and I don't recall there being a discussion about prejudice one way or the other. I think this may be a structural error issue. That once the judge loses control of the jury, I think that jury is just you can't go back and there's no way to know whether the release of control is going to affect the jury's decision on a later finding that it's asked to make.
Yeah.
Okay, the next case deals with discovery sanctions. This is DEC versus Developers Investment Company out of the 4th District Division 3 from March of 2023. $37,000 in discovery sanctions was held to be appealable, but not the related issue sanctions. So there were two different discovery orders here. One was sanctions, one was issues, one was money sanctions, one was issue sanctions. The first was appealable, but not the second. Discovery orders, can be devastating, but they're not always appealable. Under the appealability statute of CCP 904.1, sanctions orders greater than $5,000 are appealable. And so that gave the defendants in the DEC versus Developers Investment Company case an idea. The defendants got hit with issue sanctions for, quote, blatant disregard of discovery and discovery orders. And although the issue sanctions were potentially case dispositive, as the court observed, they were not appealable. But the court had also imposed some $37,000 in money sanctions, and because that's greater than $5,000, that's an appealable order. And they were related, Jeff, to the same conduct. So won't the Court of Appeal just resolve all the issues at once?
That seems efficient.
Seems more efficient, but it didn't work here. The court noted that there is a limited exception that would permit review of a discovery order as part of an appeal from an order directing payment of money sanctions greater than $5,000. But the issues underlying the orders have to be based on the same conduct, and they have to be, quote, inextricably intertwined. And here the money sanctions and issue sanctions were based on the same conduct, but they were not inextricably intertwined. It's when I read this case, Jeff, I couldn't quite follow that. It starts to get very subtle when they're related on the same conduct, but not inextricably intertwined. That seems to be one of those inextricably intertwined seems one of those non-lawyerly standards that you can just take a vote on a room full of lawyers and get different majorities on different days. But here's how the court concluded. Quote, the appeal from the order imposing monetary sanctions therefore can be examined and resolved independently of the order imposing issue sanctions. Put another way, we can and do resolve the issue of the propriety of the monetary sanctions without also resolving the propriety of the issue sanctions, end quote. I don't know. There was a lot of words. I don't know if I understood any better after reading them, though.
I think, let me summarize from your blog post on this case. Courts of appeal don't want to do anything to encourage appeals of discovery disputes or to make them easier to appeal. And so that's what drove the result here.
Yeah, no, that's a good razor. That helps understand. Exactly. Anything that's going to make discovery orders more appealable, assume that the Court of Appeal is not going to be inclined. So the upshot here is interlocutory appellate review of a discovery order usually is going to require a writ. But those are tough in any case, and especially in a case like this where the court-appointed discovery referee commented that in his almost 20 years of service as a neutral, he had never seen, quote, such blatant disregard of discovery and discovery orders. So, Jeff, in addition to just a blanket distaste for discovery appeals, this particular appellant kind of stood out as a particularly bad abuser of the discovery process. So I think the court was not inclined to deviate from its normal rule. Okay, next case. This deals with Jeff, you got a comment?
I thought we were going to skip right to the stump, Tim. You want to talk about the reversal on appeal here?
Yeah, let's go. Yeah, stump me, Jeff.
All right. I want to stump you. And by the way, if any of our listeners have an opinion on this, I couldn't find a case, and I would love to get an email from you on your opinion about this. Everybody except Fran, who I already heard from. All right, Sam. So here we go. Imagine you're in an anti-SLAPP matter, and you represent the plaintiff, and you have survived an anti-SLAPP motion. And the way you survived an anti-SLAPP motion as the plaintiff is the trial judge ruled against you on prong one, found that it was protected activity, but ruled for you on prong two, found there was minimal merit, denied the motion. The defendant appeals. And in their opening brief, the defendant completely skips over prong one and rushes right to prong two and argues how there's no minimal merit. And my question for you, in terms of stump Tim, is in light of the de novo review, is the defendant appellate required to brief prong one as part of their de novo review or presentation of the correctness of the order? And if they don't brief prong one, is there an argument they've somehow waived or forfeit this issue on appeal?
Yeah, and forfeit the whole appeal. Yeah, so from the eyes of the appellant won on prong one. I established that the defendant successfully established that this complaint arose from protected activity. It chills my free speech rights, and it can only proceed if the plaintiff shows minimal merit. But the plaintiff did show minimal merit, and I want to attack that ruling. And I'm not going to waste time on prong one because I already won on that. And just refer back to the judge's eloquent, brilliant dissertation on my prong one victory, and just reverse him on where he misstepped on prong two. But then the question is, are these two different orders? Is there, it's a prong one analysis and a prong two analysis, but it's not a different ruling on prong one and prong two. It's all part of one order asking for relief on the anti-SLAPP statute. So, and as we know, one of the fundamental appellate rules is that all intendments and presumptions are applied to affirm the ruling. And the ruling here, again, it's not a half and half. It's just the ultimate result is denied victory for the plaintiff. And while your gears are spinning in your head, let me throw two other points out there. Number one, orders are presumed correct. It's the appellant's burden on that. And number two, courts of appeal review results, not reasons. Yeah. So at the end of the day, what the trial court thinks about prong one or prong two might not be entirely relevant to the disposition of a de novo appeal. That's right. That's right. Yeah. So you start from the conclusion. The conclusion is anti-SLAPP motion denied, and then you just work backwards to see if it's all supported. That's why I don't know sometimes when I see these things. Why would a trial court make any statements favorable on any part of the losing party's arguments and say, oh, the losing party is right about X and Y, but it's wrong about Z, because then this sort of thing is going to happen. And then the appellant's going to go up to the Court of Appeal and say, see, I got X and Y right. But at least if it's a de novo review, you have to re-argue and win on X and Y all over again. I'm biased because I'm on the other side of this issue, but I'm just going to say this. Not only does the appellant have to brief both prong one and prong two, I'm going to say it is malpractice. It falls below the standard of care. If you are briefing an anti-SLAPP order on appeal and you don't address both prongs, unless there's a stipulation in the record or some sort of something binding like that. Yeah. I think so. I'm not sure if you do these a lot more than I do. Have you not seen this before? It seems like a trap that a lot of people might fall into. I've never encountered a brief either way on either side of this issue where somebody skipped over a prong. Did they just and they just skipped over it entirely, not even humming a few bars? There was a sentence where they said, well, the trial court found in our favor on prong one, correct, and that was correct. But there was no argument, and that was in the introduction or summary of argument. There was no separate argument about prong one. And the defendant had it is a burden. It's an affirmative burden on the prong one. And so you have to make it again on
Yeah.
appeal.
Yeah. Well, I'll let you know how the court rules, but I was surprised I couldn't find a single case on this. And audience, if you've heard of a case on this point, please email me.
Yeah. Jeff, would it be different if in a different context, in a different than anti-SLAPP context, which is reviewed for de novo, would it be different where the review, where if it was a factual finding instead of a legal finding? Would it be different? Would the factual finding still hold up, even if the factual finding is in favor of the losing party?
Yeah, that's interesting. You've stumped Jeff.
I think I have seen cases that say, well, I think you can make an argument either way, but I have seen cases that say that we're not going to infer things. We infer all reason, make all reasonable inferences from the record, but we're not going to infer things that are directly contrary to the record.
Yeah.
But again, because
right.
this is a de novo review on prong one. Key. Yeah, it goes away. It's a nullity.
The Court of Appeal is basically doing the same thing that the trial court does. It's kind of like MSJs. In an MSJ, if you're trying to knock out 5 elements of a claim, you don't just brief 3 of the 5. I mean, you go for all 5. Yeah, I don't understand it.
Yeah. Let's see. I had a case here I wanted to talk about concerning statements of decision. This is a perennial favorite issue I like to discuss on the podcast because it comes up so often in my conversations with trial attorneys. This is Atlantic Richfield Company versus California Regional Water Quality Control Board out of the 3rd District. This is back in December. It's a few months old. When do you have to request a statement of decision? So when I tell trial attorneys my top appellate advice, such as don't forget to get a court reporter, the most common response is I already knew that. But when I give my second most important appellate advice, which is don't forget to request a statement of decision, the most common response I get from trial attorneys is what for? The court already gave me a tentative decision, so I can request the statement of decision then. But not always, as ARCO learned in Atlantic Richfield. The court there held a hearing that lasted all of 79 minutes. ARCO did not request a statement of decision before submitting, and instead ARCO assumed it could wait until the trial court issued its written order, a tentative decision, which would give it then a 10-day period to request a statement of decision, and that 10-day period is also extended by the CCP 1013 rules for service, but that was not the case. ARCO had miscalculated because the trial court wound up denying the request as untimely because under California Rules of Court 3.1590, that's a key rule of court that governs statements of decision and tentative decisions, 3.1590. Under subdivision N, quote, when a trial is completed within 1 day or in less than 8 hours over more than 1 day, a request for a statement of decision must be made before the matter is submitted for decision. ARCO so it was untimely because they submitted, and at that point it's all over. It was only a 79-minute hearing, less than 8 hours, less than a full day. ARCO then tried an argument, turned out to be more too clever by half. Though they did have some case law to support it. But here's what ARCO argued. They said that although the proceedings only lasted 79 minutes, the judge must have then gone back into chambers and spent a lot of time reviewing the voluminous record, maybe took it down to the courthouse cafeteria, maybe took it home and worked from his home office. That all that work, laborious work, reviewing the record after the 79-minute hearing and coming up with its eloquent decision must have taken more than 8 hours. And so it's more than 8 hours. Therefore, under 3.1590, the court had to issue a tentative decision. The court rejected it and said that the court followed in re Marriage of Gray, saying that included this quote explaining, the pretty common sense way of how to calculate the 8 hours. It said that we cannot realistically expect trial judges to keep stopwatches to record the time spent off the bench. Rather, the 8-hour rule in CCP section 632 governing statements of decision requires a simple and obvious mode of timekeeping that everyone, including attorneys, can keep track of. even those attorneys who can think up all sorts of strange ways that obvious things are no longer obvious. So the time of trial means the time that the court is in session in open court, and also includes ordinary morning and afternoon recesses when the parties remain at the courthouse. It doesn't include lunches, but otherwise we just count the time that you're in open court and the basic recesses. So don't forget to request a statement of decision if you're in a short trial. Have it, have a script ready to go. Do not say, "I submit, Your Honor," until you have requested your statement of decision, or better yet, file it in writing beforehand.
Yeah, because part of your opening statement or as part of your trial brief. Why not request a statement of decision at the beginning rather than trying to game the system or predict if you're going to win or lose? Absolutely.
I've been meaning for a while, Jeff, to write up a guide, a checklist on statements of decision, because I wind up having these conversations with attorneys so often about how to do it when they're preparing for a hearing, or explaining to why they have filed something up after the fact. If I write something up, I could just send them a PDF of it. Okay, and here's one more that I thought we'd share. I thought this was kind of fun. Ordinarily, it would be newsworthy that a United States District Court allowed a brief that was filed 15 minutes late, but Judge David Proctor not only refused to strike the late filed brief, he ruled that striking a brief just because it was filed 15 minutes late would be absurd. So in the district court ruling in Whitworth versus Medrano, this was a Southern District of Alabama back in January of 2023, hat tip to Above the Law, Judge Proctor noted that, quote, "There are no doubt many other instances when 15 minutes could make a world of difference, such as 15 minutes extra time presenting oral argument, or running a marathon, or making a departing flight. But," Judge Proctor goes on, "the electronic filing of an opposition brief in this court on a late Thursday afternoon is not one of them." Judge Proctor sketched out a parody Chambers scene in a, quote, "parallel universe in which idle court clerks expectantly scan the wires in the waning minutes approaching 5 p.m., breathlessly awaiting a litigant's brief, whereupon they commit and resolve to devote their entire evening to reading, no, consuming and cherishing every syllable of this expected filing." And Judge Proctor concludes, "Only in such a distant parallel universe would striking that late filed brief make any sense." I thought, Jeff, that that maybe you bookmark this decision, and next time you need to file a late brief, consider referencing Judge Proctor's observation that, hey, a brief filed just a few minutes late could only be faulted in a distant parallel universe. It would be absurd to strike a brief just filed like 1 minute late, like the notice of appeal that we reported on last episode.
Yeah. No, it is a good case to bookmark. And by the way, Proctor's a great name for a judge to relax a rule regarding the timing issue.
Yeah. All right, Jeff, we got a few legal news and tidbits. Do you want to cover those?
Yeah, let's do a couple. Let's do three.
Three, okay. You want to kick us off, or want me to pick one?
Sure.
Okay.
I'm going to kick one off. It's not in your notes. It's not truly news. It's more of a tidbit. I demoed ClearBrief this past week, and within a couple of days, signed it up for everybody at my firm. What an amazing product this is. I got to tell you. I had heard about ClearBrief and some of its marketing materials, and I thought it's just a fancy way of hyperlinking your brief. So when you click on a brief, on a case, you pull up your Westlaw case, and it's there. Or you click on the record site, and the record comes up. And you know what? I've got an amazing paralegal who could do that for me. So I thought the product's a waste of time. Oh my God. This AI-powered product does a couple of things. First of all, it's got this magic table of authorities feature. Tim, have you ever gone through a brief and had to manually mark authorities, coded them so that a proper table of authorities can be created?
Oh, yeah. Yeah, of course.
Yeah.
It's
tedious.
Hugely
tedious.
Time-consuming.
Now, I usually have my paralegals do this. ClearBrief has this magical button. Press the table of authorities, and boom. Within about 2 minutes, even in a lengthy brief, It is formatted perfectly to California citation standards. You can have it omit, pass them, and do all the other things, all your little nuances that you want in a table of authorities. No coding whatsoever. You press a button, it's magic. That's one thing. The second thing it does, suppose you upload your record in PDF form to the cloud in a secure setting, and you're looking for a citation of the email where bad guy calls somebody a name. You could type into a search field, and it will give you 15 suggested sites of where that appears in the record using AI, not a Boolean search, but more of a fuzzy logical search. And when you get to the one that you like, and if it's correct, you press a button and it automatically inserts in your Microsoft Word brief the citation to that evidence. And then when the brief is done, you click a button and it creates a linked, fully hyperlinked, beautiful brief that you can email to the clerk or your opponent or client with clickable links for every case and every citation to evidence. I can't endorse this product enough. It's game changing.
Yeah, I was impressed. I demoed it last year, and yeah, I was impressed by it. One thing, one limitation. I think this was a limitation, that if you're looking for a piece of evidence, you're looking for a statement or proposition, looking support for it, and you type it in, and you wind up getting a whole bunch of results that are from my own complaint or from my client's own deposition testimony, or trial testimony, and things that are, yeah, that's directly on point. That's why we set it at trial and in our pleadings. I want to find where the other side's evidence supports it. That's a little bit more difficult for maybe AI to figure out.
Yeah.
The source, the foundation of the information is as important as a textual match for the proposition.
Yeah. Well, let me say this though. One other feature: you upload the bad guy's brief.
There you go.
And it hyperlinks it. And if you've got the record, and if the bad guys did a pretty good job of citation in a uniform way, it will hyperlink the bad guys' cases and record citations, so you can click each one and say, does the record really say what they say it says?
Yeah. No, that's very true, because sometimes you, by the time you get the bad guy's brief, it's been some months before you looked at yours. You can't quite remember your arguments, how strong they were, and then you're reading theirs, and that's a good point. And then they got a citation for it, so it must be true. But if you could instantly see what they're citing to, you can see where their weak spots are.
Yeah. So my final word on this product is it's a Microsoft Word plugin or add-in that anybody could just add in without paying for it. It's effectively a free trial. And then after a few days, I think the folks at Clearbrief call you and ask you to set up an account. But if you want to play around with it, you go to Microsoft Word's add-in store and download it. And I highly endorse this product. It's going to save a lot of time on brief preparation.
Yeah. All right. Here's another a legal tidbit, bit of legal news. We've mentioned a couple times about California Supreme Court granting review of cases involving COVID insurance cases. The Supreme Court recently denied review in SVAP 3 Poway Crossings LLC versus Fitness International. That's a case where the 4th District Court of Appeal had published an opinion holding that a fitness facility was not excused from paying rent when government orders shut it down for several months because of the COVID pandemic. So, there have been a lot of people watching to see if these if insurance coverage was going to apply to COVID-related shutdowns, COVID-related claims, and there hasn't been a lot of published authority. I don't know if there's any published authority. I think maybe there was one recently, just a few weeks ago, or a couple of months ago. But it looks like in this SVAP Poway Crossings case, sometime maybe later this year, the Supreme Court will come out with a published decision about COVID coverage and insurance policies.
Interesting.
There was another case or another bit of news out of from law.com, why Judge Charlotte Sweeney is adding pro se summaries to her rulings. I thought this was interesting. Here's Judge Sweeney's comment about the importance of giving some kind of some summaries that could be digested easily by non-lawyers to introduce the holdings of cases that come out. The quote is, "The idea that we could simplify this in a brief introductory paragraph and help that person understand the bottom line of a decision is really appealing to me." Judge Sweeney is a district judge from the United States District Court of Colorado. I thought that's an interesting case. I think anything to make the cases. We get a lot of cases coming out of our appellate courts, and some of them do provide the helpful synopses of what they state. I think our California Court of Appeals do a good job of doing that, and so I endorse that practice.
Yeah, no, it's fantastic practice. Justice Rubin of the Second District and Justice Bedsworth of the Fourth Appellate District both do amazing jobs in the writings in summarizing nicely the case before getting into the weeds. And in particular, if either of you are listening to this podcast, I'd love to have you on as a guest.
Absolutely. All right. One other I thought that was interesting. This is a case we could do a summary on, but a judgment creditor was unable to seize an Academy Award Oscar. This case involved affirmance of a post-judgment order. The court ruled that by virtue of a contract between the Academy of Motion Picture Arts and Sciences and the award winner David Ward, who won the 1974 won the award in 1974 for best script in
for The Sting.
For The Sting, yeah. But the Academy had the right. Contractual buyback right, first right of refusal at $10. So the judgment creditor could not seize the Oscar until the Academy was first given first right of refusal to buy back the Oscar for $10. So that limited the value of the Oscar to $10, and the Academy had a first right of refusal. Thought that was an interesting case. If you ever want to ensure that an asset, a valuable asset, cannot be seized by a judgment creditor, just make it subject to a first right of refusal.
Yeah, although the Academy Award contracts might be given a lot more deference than, let's say, a sham contract to avoid collection.
Okay. You said only 3, Jeff, but I'm going to cheat and do one more in here. This is an interesting one about CCP 998 offers.
Yeah,
Jeff, this is just such a quagmire. These 998 offers. You just when you think you understand it, there's a case that throws you upside down. So in this recent case holds that the 998 offer applies even where a case settles. So you know that if you make an offer and you don't beat it in the judgment, then you're going to be liable for costs and expert fees. That rule applies even if the case doesn't go forward to a judgment and you settle for less than the offer. But this was a split decision. Acting Presiding Justice Ronald Roby dissented, arguing that the cost-shifting provisions of 998 should apply only where a plaintiff suffers a defeat at trial or gives up the fight, not where there's a settlement.
Yeah, this was an interesting one. With that dissent, maybe it'll go up to the California Supreme Court. I'm struggling to figure out why there was a settlement that didn't deal with all the issues, attorney's fees and costs, and why they left costs open. But okay.
Yeah, that seems like it may have been an oversight.
Yeah. All right. With that, let's close this episode out. We want to again thank Case Text for sponsoring the podcast. Each week we include links to our cases. We discuss with Case Text's daily updated database of case law, statutes, regulations, codes, and more. And remember, listeners of our podcast enjoy a special discount on Case Text basic research at casetext.com/CALP. That's casetext.com/CALP.
And if you have suggestions for topics that we should discuss in future episodes, or guests that we should invite on the show, or if you would like to be a guest and you have a great story or topic to discuss on the episode, we'd love to discuss having you on. Please contact us at either of our email addresses. If you can find them, they're on the State Bar website, or you can email us at info@calpodcast.com. And in our upcoming episodes, look for more tips on how to lay the groundwork for an appeal when preparing for trial.
See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.